Life is a journey that we all taken. Every step is guided by its own rules and law. So come to Tann Law. Come to Tann Law. Tann Law, to Tann Law. Tann Law, to Tann Law. Tann Law, to Tann Law. Immigration and family law, employment law and corporate law, commission of votes and all the other laws, professional and friendly services we give you all. For all your immigration law, family law, employment law, business and corporate law, welfare benefits, charity law, will, commission of all litigation, come to Tann Law Solicitors or simply visit our website on www.tannlaw.co.uk or simply call us on 024 776 32323. Tann Law Solicitors, professional and friendly service.
My name is Andrew Nyamayaro. I'm the sole and principal solicitor at Tann Law Solicitors based in Coventry here in the United Kingdom. I'm here again to make a presentation on some legal updates for this week, and I will start again on a topic on immigration. One update that is important is that since the 31st of August 2021, electronic tagging has become compulsory in bail applications for those people who are facing deportation and might be recommended by judges or when requested by the Home Office. So if someone is facing deportation, they have to be electronically tagged as part of the new requirements. I do understand that the system of electronic tagging has since moved forward. The technology has moved forward. I understand that it's now not the old system whereby they would come and put in a box in your house and then they will monitor you from there. It's now you can be monitored from anywhere. You don't really need to have a box fitted into the home because it's based in the clouds. So I am told, but it's still the early days. Even the courts are still getting used to it. So it will start to appear in most of bail conditions that someone might be requested to have an electronic tag. Having electronic tags is not a new phenomenon. It used to be there. Then there's always issues about human rights, freedom of movement, and so forth. A lot of questions that can be asked again around and against it. But as it stands, electronic tagging, if you are facing deportation, is now compulsory for it to happen. Maybe this might face challenges in court in due course. We are yet to see. Other legal updates that I have in terms of immigration is that the Home Office has or had the COVID-19 concessions or policy which they had, whereby if someone could not travel or cannot travel to their home country because of COVID-19 related reasons, then they can apply for an extension of their visa within the UK and through the exceptional assurance facility that is there. I think now for most countries, especially those in the green zone, this has gone. And for those who are in the amber or red zone, if you can prove your case, you can still apply for exceptional assurance. But I think this is something that is going to come to an end anytime soon because the lockdown in the United Kingdom has come to an end itself, and there's a relaxation. We just hope and pray that with these children opening schools, there won't be another spike of infections and deaths. So, if you are not able to return to your home country because of COVID-19 related reasons, then you can make an application for exceptional assurance. Whilst on that same topic, it is a requirement that if you are coming from a red list country, then you have to go to those hotels for quarantine. And those we hear that the conditions in the hotels are quite bad. We see on social media some of the food that has been given to people. It's horrendous. And people are not keen to go there. I understand that quarantining people in hotels has been challenged in court. I understand that there's judicial reviews going on, and also people have come up with ways of evading or avoiding the quarantine in the hotels. So, if it is possible for someone to pass through a green list country and spend at least 11 or so days in that country, then they can be, when they come to the United Kingdom, they will be able to quarantine or to self isolate at their own home rather than to go and quarantine in the hotel. Two reasons are important there. It's cheaper to do that, I understand, and it's also convenient since you'll be at your own home and having the food that you like and having the entertainment and the company that you like, rather than in a hotel where most people are now calling it, it's almost like a prison environment. So that is about the COVID-19 in terms of quarantine and isolation, and in terms of extending your visa under the exceptional assurance. If you have got any questions in relating to what we are discussing today, kindly send us an email on the email info@tannlaw.co.uk, or WhatsApp us on that number that is on the screen, or call our office and one of our lawyers should be able to respond to your inquiries. Under employment law, I'd like to comment on social media. So many a times people do post things on social media. It could be for their own family, or things that has happened or happening at work and football, different topics at church and so forth. But most employers have got a social media policy, and before you post anything relating to your work or to what you do at work, be careful that you are not breaching the social media policy of your employer. You risk losing your job if if you breach or go against the social media policy of your employer. There is no cast and die requirements or anything that is set up in iron that this is what you do, this is not what you do. It depends on the social media policy of your employer, and also some things are not acceptable. If, for example, you are commenting about particular cases or issues that are happening at work, or you are talking about a particular individual that can be identified, it could be a client or a colleague or someone that works with you, and some certain types of behavior as well might jeopardize your your work as well. So we need to be careful when we are on social media. In and some of the comments that you might do on social media. I was just reading, I think, sometime this week about a footballer or a celebrity who put a comment on social media when he was 14 years, and now in his 20s it has come back to haunt him, and I think he's been suspended from his duties, whatever he was doing. So be careful about social media. And some employers these days, before they employ someone, they also check someone's social media. Whether or not that is right or wrong, it's another question. But some do pro through the social media, Instagram, Snapchat, Facebook, and so forth. And if they see things that they think are unprofessional or will jeopardize their company or what they do, then they might not employ you. So it is very careful to consider what you do on social media and what you post, because that might, if you're employed, affect employment. And if you are looking for employment, then that will also affect your prospects of getting a job to be employed. Under the topic of employment, again, I would want to comment on the issue of what has now become to be known as no job, no job. There's some policies that are being put by companies, particularly in the social and healthcare industry, where their employees work with vulnerable people, and there is almost a requirement that an employee, a carer, a support worker, or someone dealing and working with vulnerable people should have to be jabbed, hopefully twice, that they can be able to work with vulnerable people. I'm not here to talk about the advantages and disadvantages of being jabbed, and the theories, conspiracy theories, and supporting theories with jabbing. But we are moving towards a time whereby I think most employers will require employees to be jabbed before they can do their work, particularly if they are working with vulnerable um, individuals or vulnerable people. I do understand again that there is a case in that is going on, a judicial review on the government position on this topic of no job, no work, and we will I'll keep you updated as to what happens. Some people have not taken the jobs for various reasons. Some because of their religion, personal beliefs, because maybe they are vegan or vegetarian, and so many reasons why people have not taken, or even medical conditions. Some people might not have done that. So I'll keep you updated. Just watch this space. Last week, I sent a post that generated a lot of interest from people. This was in relation to a prenuptial agreement or a contract. So, in most jurisdictions, when people are getting married and they have their own individual assets and properties, they make an agreement whereby they will say that whatever you accrued before we got married belongs to yourself, not to the other party. So what the husband or the husband accrued is his, what the wife accrued is hers, whatever partner accrued is theirs. So, so that at the time of divorce, well, hopefully they will not get divorced. But if it happens that they are getting divorced, then at that time, whatever was before the marriage will not be shared. Whatever then was acquired during the marriage will be shared. Here in the United Kingdom, people can enter into prenuptial contracts. Some people do in prenuptial contracts or agreements. It's not something that is enforceable necessarily in court, but it's something that if it has been done, the court will give weight and credence to it. So if you've got a prenuptial contract in the United Kingdom and you get to a time of divorce or separation, the court will give weight to your intentions as to why you entered into the prenuptial contract, and hopefully your properties will be divided according to what both parties intended and wished for it to happen. So I encourage for people who want to get into marriage, they can consider a prenuptial contract. These days, we have got a lot of young people, both male and female, our sons and daughters that are doing very well, and they're accruing their properties quite at an early stage. By the time they get married, the young girls or the young gentlemen have got houses and cars and savings and so forth. And if they believe that it's something that they can consider, then they can do a prenuptial contract. The last thing that I want to touch on is the issue of fellow. Now we know that since March 23 of last year, when there was the lockdown, the government has been helping companies that were struggling or that were closed with payments for their employees. and other benefits that companies were receiving through help for the COVID. It could be loans or grants, or in the healthcare industry, some companies were being given PPE, which originally were very expensive until people started being given for free by the government and so forth. All these things now might start getting to an end, and we know that if it does not change, fellow payments will come to an end, I believe, on the 30th of September. So employers are receiving help to pay their employees through the fellow um, system, which is there, and the percentage has gone, has been decreased. Now I think we are on 60%, which the government will contribute. So that will come to an end as well. So that is going to mean that if a company is not performing so well, then it might have to make some employees redundant, or it might have to enter into some settlement agreements with some of the employees. The redundancy and settlement processes should be done in a fair and timely manner by the employer, and there should be no prejudice to the employees, favoritism or discrimination, and there should be justifiable reasons why an employee is being made redundant or a settlement agreement is being made. In terms of the settlement agreement, obviously it needs to be legal, it needs to be enforceable, and most settlement agreements will have a clause whereby you cannot then come in future to try to claim more from your then previous employer, because you would have said that any rights that you have, you forego them, and you have to be paid your salaries, your benefits, whatever you agree in terms of the settlement agreement. If you find yourself in such a situation whereby you will need assistance from a solicitor in terms of redundant or settlement agreements, here at Tann Law, we do have lawyers that specialize in employment law, so they can help you with redundancy, or they can help you with settlement agreements. We can review your settlement agreement. We can advise you if you're being paid fairly, or the terms and conditions of the settlement agreement, if they are fair to you, or if anything needs to be changed. We have negotiated for other employees or clients to have their settlement payments increased by the employers, and we have been successful to some extent in that regard. If you require legal advice, whether you're in the United Kingdom or outside, Tann Law solicitors can help you in immigration, employment, civil litigation, family. We also draft wills, which is an interesting topic, because people sometimes are afraid to have a will, or just think a will is not important or necessary. A will is important and necessary, because when you die without a will, you've died intestate, which means that the laws of that country will then determine how your property, your estate is going to be distributed. But if you die with a will, you've died testate, and your intentions will be carried out as to how your property is going to be distributed. So it is important, in my belief, that someone should have a will at all time. And if your circumstances change, your assets change, your wishes change, you can always amend the will, or rather not amend, make a new will, and revoke the old one, and make a new will, and so that your intentions can always be carried. It is sad that at the moment there's a high rate of deaths of here in the United Kingdom, in Zimbabwe, or elsewhere. So it is important for someone to have a will. I would also encourage people to have a lasting power of attorney, whether it is the finance one or it is the health one, in case you are not able to mentally make decisions for yourself, or you cannot physically be able to do certain transactions yourself, then if you've got a lasting power of attorney, the person that you've appointed to be your attorney will be able to make those decisions and to do whatever you've asked them to do in terms of the power of attorney, the lasting power of attorney. So a will becomes effective when you die. A lasting power of attorney becomes effective while you're still alive, but because of mental health issues or because of your health, you cannot execute certain transactions, then you can have someone whom we've appointed as your attorney to deal with those matters. We are also commissioners of oath, and we also give advice to businesses, commercial and company advice that we also give to businesses. So if we cannot assist you, then we can also signpost you to colleagues that we trust. So contact us when you require an assistance, and Tann Law solicitors will be able to help you. My name is Andrew Nyamayaro, and thank you for watching. Thank you.